Welcome and good afternoon, everyone. The court is on the record, and this is in the matter of Moore Murphy Hospitality, LLC, doing business as Iron Pig Smokehouse versus the Michigan Department of Health and Human Services. This is case number 21-18522AE. Counsel, if you can go ahead and start with your appearances, please.
Good afternoon, Your Honor. David Delaney appearing on behalf of the Iron Pig.
Mr. Fowler, you appear to be muted. So I'm hitting the button asking you to unmute yourself, and then you can join. And while we're waiting for him to do that, welcome Mr. Murphy to you as well. Mr. Fowler, can you hear the court? All right, so there's an issue with your microphone somehow. Now it seems to be on. Go ahead and announce your appearance, please. So now my system is showing that you're connected, Mr. Fowler, but you're still not, and I'm not sure if that's an error on my end or on yours. Let's go ahead and try one more time, though, because I still can't hear you speaking. Notably, I'm here in the circuit courtroom for Crawford County because there's a trial ongoing in Otsego County. That's why we're joining from a different location, and it looks like Mr. Fowler is trying to turn everything off and turn it back on. He's still in my hearing room, so we'll give him just a moment.
For the record, Your Honor, the court can see and hear me.
I can. Thank you very much.
Okay, thank you.
All right, Mr. Fowler has now left the waiting room. I'm hoping that he's just resetting the system and he's going to join back in soon. And when he does, I'll admit him into the hearing. Until that time, I'll just ask that everyone remain silent. And then once he's here, we can start the hearing. Okay, so it looked like you had volume for a second, and now it's muted again, Mr. Fowler.
Can you hear me? You can hear me?
I can. Everything's good. Thank you.
Wonderful. Yay. Okay.
All right, Mr. Fowler, if you could go ahead with your appearance, please, and we can start the hearing.
Thank you, Judge. Darren Fowler from the Attorney General's office on behalf of the Michigan Department of Health and Human Services.
Thank you. So, counsel, welcome back again. As I stated just a moment ago, I'm here in the Crawford County Circuit Courtroom. That's because Otsego County Circuit Courtroom was otherwise occupied today. And counsel, obviously, everyone is joining me via Zoom. So thank you for your appearance. We're here today because I wanted, and I thought I might benefit from oral argument and additional briefing on behalf of the petitioner on respondent's motion after my opinion and order. And so I've had a chance to review that, both the motion and the brief in support of the motion. I've had a chance to review the response to the motion, and now I'm going to permit oral argument. Just to be clear, I understand the motion to be three-part, basically asking me to reconsider, asking me for clarification, and or asking me for a stay while the impending appeal to the Michigan Court of Appeals is ongoing. And so if I've got that wrong, obviously parties just go ahead and correct me on it, and I'll take that into account. Ultimately, after I hear first from the Michigan Department of Health and Human Services and then from Iron Pig, I'll ultimately have some concluding remarks, and ultimately, again, as I did last time, I'm going to issue a written opinion and order. So any question about how we're going to proceed today, Mr. Fowler?
No, Judge.
Mr. Delaney?
No, thank you.
All right, Mr. Fowler, then your argument on behalf of the department.
Certainly, Judge. And I'll simply say, before the hearing today, my staff has emailed to your staff, Judge, the application for leave to the Michigan Court of Appeals that the Department of Health and Human Services filed yesterday by operation of Michigan Court Rule 7.114C. The proceedings here in the circuit court are now stayed. The effect of that order is stayed, rather. So from our vantage point, it does not have operative effect. So making sure that you are aware of that. Beyond that, Judge, to the extent there are other concepts in our briefing, we certainly rest on those, but we think that the stay by operation of the court rules at this point is the controlling factor.
So why did you file the motion then instead of just simply filing the application for leave to appeal?
We needed time to get the application ready for the Michigan Court of Appeals, Judge, and in the interim, we had been hoping to demonstrate for the court through the briefing that the order was creating problematic confusion out there about the continuing operative effect of Section 2253. So we had been seeking that clarification, but as of yesterday, with the filing of that application, again, that matter has been resolved by operation of the court rule.
So in other words, we're wasting time by even being here today on the motion that you filed.
Judge, we filed that motion because we thought it was very important for this court to make clarification because of how Iron Pig was representing the impact of this court's order. We tried to.
Well, I understand, Mr. Fowler, why you filed it, and I don't take issue with the fact that you filed the request. But now that you filed your application and your citation to the court rule, would make any further proceedings here, if your interpretation is right, it would make those further proceedings moot, would it not?
It would, Judge. We wanted to be here today because the motion had been teed up. We know that you and Mr. Delaney had spent time on it. So as a courtesy to all concerned, appear and explain where things are from vantage point of the department.
All right. Anything further, Mr. Fowler, before I hear from Mr. Delaney?
No, Judge.
Mr. Delaney, your response to any of the oral argument or the written briefing by the department?
Well, first of all, Judge, the appeal was filed. I received the appeal at about 7 p.m. Yesterday, so I've not had an opportunity to review that and or reference to the court rule that's been cited. I'm not entirely clear the position of the state. An appeal does not automatically stay the lower court if that's what the state is indicating in this case. There are times that an appeal divests the jurisdiction of the lower court. In other words, an appeal is timely filed and then the lower court does not take any further substantive action, obviously, because that would disturb the appeal. There are some miscellaneous authorities that would allow that, assessment of costs or some of those issues that are not substantive. With respect to an application, the lower court is not divested of jurisdiction until such time as the application is granted. But because of the timeliness of this, I mean, I was having dinner when I received this, so I've not had a chance. I was in Alpena this morning, so I'm not clear what the state's position is. I am prepared to briefly argue the issues. I filed the brief. I really don't have anything to add beyond my brief, Judge, but I would supplement by oral argument if the court so requested.
Well, that's why we're here in my view. And I just heard about this citation to the court rule right now. And so I'm not going to rule on that orally right now. So yes, if you wanted to provide oral argument, you're entitled to. That's why I set aside time today.
Thank you, Judge. Relative to the request by the state to stay, the court can see from the in re certified decision, which was the cornerstone of the court's ruling, that the executive branch at that time requested a stay of precedential effect, which the court denied. Even the dissenting Chief Justice indicated that there was really no remedy in that regard. I've not been familiar with that type of proceeding before where the court's asked to address precedent. Precedent is what it's going to be in this case. With respect to precedent, and I briefly reviewed it in my response, the court's ruling with respect to precedent and the decision is firmly rooted in the Michigan Constitution. And I trace that from the Constitution through the Administrative Procedure Act. And so I won't elaborate further other than to say that the court's decision, again, firmly rooted in the Constitution. What I will say, Judge, is that we had a stipulation and an order between myself and the state of Michigan to decide two issues: whether 2253 violates the non-delegation clause of the Michigan Constitution, and whether the MDHHS orders are rules. And the court ruled on those decisions. Prior to the stipulation, I was not asked, or was it suggested that, well, in addition to that, once the court rules, we'd like to stay those rulings. There are some cases that are adversarial from the beginning and the party can seek a stay. We really had a stipulation of facts and a stipulation of law, quite frankly, and the court applied the law. And so my only position regarding precedent, which I've not been called on before to ever respond to, is that the decision's binding on MDHHS. I mean, that's clear from the ruling. Relative to a stay, Judge, one of the factors is harm to the Iron Pig. As the court is aware, and it was outlined in the court's decision and the lower court record, this being the lower court, well, the lower court being the administrative record, the liquor license of the Iron Pig was suspended and they were fined. The food license was suspended and fined. And particularly egregious for my client, Judge, he was personally found in contempt of court by the M County Circuit Court, entirely premised on a violation of 2253, and he paid a steep fine. And so to the extent a stay is granted, Ian Murphy and the Iron Pig have remedies available. If the decision stayed, then those remedies are stayed. Should he pursue anything in the Court of Claims, then he has a year to do that. The appellate procedure could easily be 18 months in the Court of Appeals, maybe less, maybe more, or the Supreme Court. We could be in this for years. And I think that those would be harmful to the applicant. But referring back to the Michigan Supreme Court and the House decision, which was a companion case to In Re Certified, neither court stayed the effect of the striking down of the Emergency Powers Act at that time. Finally, Judge, should the state exercise rebuttal in this case, the In Re Certified decision found the Emergency Management Act to be constitutional and the Power Act to be unconstitutional. And I thought it was insightful in the House case that the court said the following, that the executive branch and the legislative branch should work together, and the court pointed that out in its opinion, in a cooperative spirit and in a constitutional manner to respond to the pandemic. So 2253 is not the only statute which has now been struck down that could address the remedy. In fact, the Emergency Management Act is much more broad and has local impact. There are counties in the state of Michigan that have enacted recently the Emergency Management Act to respond to the pandemic. So there are adequate tools for the state and local. And if the state chooses to respond, I would request that they respond to that question about the Emergency Management Act. So thank you, Your Honor.
Thank you. Since Brother Counsel invited your retort or reply, did you have any, Mr. Fowler, on behalf of the department?
I'll simply say, Judge, that in light of the operation of MCR 7.114C, it is unnecessary to reach the arguments outlined by Mr. Delaney. I'll refrain from the balance of his invitation. To the extent, Judge, you see it differently in terms of that, the operation of that court rule, we rest on our briefs.
Thank you. So this case may be simple and it may not be, and I'll make a determination on that in my own view with the assistance of counsel's argument, meaning it might be easy because if there's an automatic stay, no decision of mine would have any operative effect. And if there's not, then I'll have to make a determination and I'll decide that. But some history is still in order in terms of the court's background, which I think sometimes the attorneys intentionally or otherwise miss some of that history. And so I think it's important to go through the history as I see it in this case, in terms of how I've been involved. And that is that this statute that I've examined and that the parties asked me to examine was issued, and that's first effective date all the way back in 1978, some 42 years before the parties in the instant case and any legal disagreement whatsoever. That statute was later amended in 2006. As a result of the statute, it's absolutely clear that the Michigan legislative body plainly delegated to the executive branch lawmaking authority. On the basis of that delegated authority, that's when the Michigan Department on November 15th of 2020 issued the instant orders, which affected to this case, stopped indoor dining. It's clear from a factual perspective that Iron Pig defied that order. They remained open for 5 days. The department thereafter, among other things, fined Iron Pig the amount of $5,000 based upon those violations and the authority under the statutory framework. Iron Pig then requested and was granted a hearing in front of the Michigan Office of Administrative Hearings and Rules. And after hearing the administrative law judge granted summary disposition, he found that there was no genuine issue of material fact remaining regarding whether or not there was a violation. Iron Pig, of course, then filed the appeal to this circuit court. In the appeal, among many other contentions, Iron Pig directly claimed and alleged as count 2 of their appeal that the enactment of the statute violated Michigan Constitution's non-delegation doctrine. Ultimately, there appeared to be various discussions that did not involve the court between the parties. The parties eventually both signed a stipulation and presented to the court. The stipulation, of course, means that the department's attorney and Iron Pig's attorney agreed that many of the counts asserted in the appeal would be dismissed and that then the matter would proceed as an appeal from the administrative agency, and that the court, quote, will decide two legal issues, unquote. First, whether the emergency orders issued in the case were rules within the context of the APA, the Administrative Procedures Act. And second, whether the statute 333.2253 constituted an impermissible delegation of lawmaking authority from the legislative to the executive branch. Based upon the stipulation, the court ordered that it would decide those two legal issues. And again, the parties asked the court to rule whether the statute was constitutional, and the court agreed to do so. The parties then spent a great deal of time, effort, and therefore money on behalf of their clients, briefing those two issues. That included a total of 37 pages of briefing and analysis by the department and 18 pages of briefing by Iron Pig. I decided then each of those two legal issues in a 31-page written opinion and order. After my determinations, about a week later is when I got the instant motion by the department, which told the court three things, three requests, but also three things directly within the content of the department's order, or request rather, motion. First, the department would be issuing new orders under the statute that the court had ruled unconstitutional and severed from the Michigan Department of Health and Human Services, the Michigan Public Health Code. Second, told the court that it viewed all prior orders under the statute as, quote, remaining in full force and effect, or remaining in effect for the time being. And three, told the court that, again, why we're here today, or while we were here today earlier, was that clarification was needed and or that the court ought to issue its own stay pending appeal. So again, whether the background history is helpful or not, it's helpful to me in analyzing how we got here, and that's where we are now. So the court will issue a written opinion indicating either whether first, I agree with the department that there's an automatic stay. Second, if I disagree, my findings on the balance of the motion. I will attempt to get that out very quickly, and the parties will receive copies of it. Thank you, counsel.
Thank you for your time, Judge.
Thank you, Your Honor.